on behalf of the people, PD2796. Defense.
Good morning, Honor. Legal Defender for Sexual Offense, PA3973, on behalf of Jarvis, together with legal counsel Reagan and Warren Butler.
And good morning, Honor. Good morning to your staff, different defender services, January PD2125, on behalf of Jarvis.
Good morning, Honor. Warren Butler, PA126, also legal defender service on behalf of Mr. Butts.
Thank you. Mr. Butts is also joining us in the court. Mr. Butts, your name, please. Right, thank you. Gentlemen. Right, attorneys, thank you for your patience this morning. We had a relatively short chambers conversation about these cases this morning. And just to briefly summarize the facts, you intend to obviously with regard to some outstanding discovery on the case in a 2-1 test homicide charge. Is that accurate?
That's correct, Judge.
All right. It's also my understanding that there are 2 motions to Washington filed today. The parties, that the people submitted a written response to the motions. Washington had an opportunity to review them. Parties are ready to argue those motions. Is that correct? We are good. Okay. Very good. All right. Well, let's start with the file. Mr. Butts, here you arraigned on the file ending in 4478.
Mr. Butts, with the following information, and the court general counsel saying staff.
Counsel, was the examination held in that?
It was.
All right, before you get that transcript ordered, and with that, what are the respective motions to quash, or do you want to address the discovery issue?
I think we can do go ahead and motions and then we can discuss the discovery again.
Okay, very good. All right, who's going to take the lead with that?
Thank you. So, Your Honor, I did file a motion to quash for deleting each case, ending in 6232. For the sake of privacy, I won't mention the complaint witness's name, but, Your Honor, there was a preliminary examination held in this matter. There was one witness called. The complaint witness was the only witness called. She testified that at the time.
Okay, do you want to, why don't we have Mark give his, on the second matter, and then we'll hear one response from people. You're okay with that?
That's fine.
Okay.
So this is then with regard to the case ending in 24101. And sorry. Okay, and this is Lauren Butler, PA126. So just to overview the facts from that case, I want to emphasize that this is only with regard to one of the 2 instances described. The complainant described 2 instances, but only one of them has been charged as first. And I am only arguing with regard to that particular charge. So at the preliminary exam for that instance that was described, the testimony included bare panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. The prosecution had the burden at the exam of establishing evidence of every element, and that included penetration. And again, the case law is clear on this. In particular, the case I cited in my motion, People v. McNeese, while that is unpublished, is particularly relevant because it highlights this distinction where it needs to be more than just it uses very similar language to that used in the exam here with this emphasis on touching vagina, rubbing the vagina. That's not enough for penetration. And there was even specified testimony about underwear hands over, and yet even with that fact, the court still held that this was not penetration. That's similar to what we have in this description of some degree of touching of that area, but that alone is not penetration. It also relies on published case law, People v. Payne. Rubbing one hand, where it includes that rubbing one hand over another vaginal area does not qualify as penetration. I'd also like to address the response from the prosecution to this motion, because the argument they're making was not reflected in the preliminary exam testimony. Specifically, there was no testimony about inside the vagina. So while they're now arguing that that is possible, it's not the testimony we heard. We didn't hear this contrasting of the labia and the vagina. And this diagram that is
Dawn's noticed you.
Penetration requires any sort of intrusion, however slight. And we use the term genital opening rather than vagina, so that penetration of the labia majora is sufficient to establish penetration or homosexual contact in the first degree. Here, the complaining witness testified that the defendant rubbed her on her bottom part where the pee comes out. When we think about basic anatomy, we know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there, but we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. So when this complaining witness testifies that he rubbed her bottom part where the pee comes out, she's referring to an internal structure, their vibration. The examining magistrate, output, she found that it was a question of fact. I don't believe that there's any abuse of discretion by that, and I believe that there's satisfactory testimony, at least to a probable cause standard, for that count. And do you want me to go on to the next one?
Please.
Okay. In the second case, extremely similar. This one is specifically, this complaining witness starts off by saying, you know how somebody would play with you in your sleep, like you would feel them in your ear, like this or something. We don't have what she was demonstrating, but she's playing with her ear. He was doing that to my vagina when I woke up, and I was crying. I stated, all right, when you wake up feeling something? She said, yes. I asked, where do you feel something at? She says, at my vagina. I said, what do you feel at your vagina? She said, I feel like somebody's playing with me. Like, I don't know, like somebody's trying to touch you but not wake you up while he's touching you. And I said, what part of him is touching you? She said, he's using his hands. She later confronted the defendant about it. She asked her why I was acting so weird towards him. She said, you don't remember what you did to me? The defendant, looked me dead in the face and said, I remember doing that, but if I did do it, then I'm sorry. Again, the reviewing standard is abuse of discretion. And here, similarly, she testified that she felt the defendant at her vagina, that she felt the defendant playing with her, using his hands at her vagina. It's more than just mere contact, mere brushing against a vagina, or just merely touching on top of it. It's an intentional act at her vagina. By stating she felt the defendant's hand at her vagina, she's testifying to penetration. She did not state that she felt his hand on or over her vagina, but rather at her vagina. Again, we look at basic anatomy, Judge. The vaginal opening is beyond or inside both the labia majora and the labia minora. And so, because sexual penetration is defined as the labia majora and beyond, the vaginal opening is beyond both the labia majora and minora. And so, by stating that she felt the defendant's hands at her vagina playing with her, she testified to penetration. And I believe that there is satisfactory testimony on the record to satisfy that to the probable cause standard, which is, again, probable cause standard is the lowest standard, and abuse of discretion is the highest deference to the examining magistrate. And I believe that they both create questions of that.
Thank you. Your defense. President Trump says America is the most beautiful.
In all seriousness, point where we get put on the record at the preliminary examination. All we had at the preliminary examination they were touching at the area. We have young ladies who, all the way at the each and every week, but they charge a CSC in the first degree. In neither case was that proven, was that ascertained. We just have speculation, and to put those charges in front of a jury was simply wrong. It's actually to deny to rent one motion to watch.
But I'm just curious what he was like saying. I think in my case in particular, there's this emphasis on the word at. There's just no, it's not realistic to say that that's what at means. This comparison between at and over is really not what plain meaning tells us about the word at. It's very different from inside all of the, what Mr. Rance really just emphasized. So yeah, I would object that this should be suspended.
Right, thank you. Right, well, a motion to quash, two motions to quash, and as the court has to review the record for use of discretion, as already been pointed out. Use of discretion standard is a high burden, and defense lawyer, when they're making oral arguments, they challenge the sufficiency of the evidence presented on the finding over respective counsel, second one, first degree, regarding the issue of penetration. The court has had an opportunity to listen to the respective arguments from the attorneys here today. I've also had an opportunity to the prosecution burden to show competent evidence. I'll start with the case where he is alleged complainant. There's deeper portions of that declaration transcript starting on page 15. And it notes line 20, for answer to a question, he touched my private part where I used the bathroom. Question, okay, and when you use the bathroom, what comes out? Answer. Question, urine, okay, tell me about part. Tell me about what part touches you there. Answer, his hand. Question on the following page, okay, what does his hand do when he touches you there? Answer, he rubs my private part with his hands. Question, okay, was this, so when he's rubbing your private part with his hands, is this on the top part? Answer, the bottom. Question, the bottom part, okay? Answer, yes. Question, okay, is that where the key comes out? Answer, yes. With regard to the file where the alleged complainant is directing the attorney's attention to the pertinent portion of the testimony on this issue of penetration, page 83, line 14, multiple paragraphs to her respective answer, reading, and you know how you, like how somebody would play with you in your sleep, like you would feel that. And I think the pertinent part of this answer is relevant to this determination is next great purpose. And again, it's like you would feel that, quote, or here, like this or something. I was doing that in my vagina when I woke up, and I was crying. Moving to the next page, page 84. Question, okay, where were you sleeping? Answer, I was sleeping in the bed. Again, question, you were sleeping in the bed with your dad? Answer, yes. Moving to page 85, line 8, question, all right, when you wake up, kind of wake up, answer, yes. And where do you feel something at? Answer, my vagina. Question, what is it that you feel at your vagina? Answer, I feel like somebody playing it. Like, I don't know, like somebody like trying to touch you, but trying not to wake you up while you touch you. Question, okay, do you know what part he's using to touch you? Answer, he's using his hands. So discretion by the respective counsel, section 1. I think that there was sufficient evidence presented from each of the elements, specifically the elements of high-touch files to line over, and attorneys would respectfully deny the motion to motion.
With Kristen's help, we've built.
Lord have mercy. What is they doing in this trial? Come on, commercial. I'm gonna have to fish you, honey. Cause we can't be doing a commercial.
So attorneys, we got a couple of items to get into the discovery.
So one of the largest uses is the CSLI that was used at the preliminary examination, which the prosecutor, causes, witness, and surplus have seen of where certain pieces of evidence were located.
And so we're clear, counsel, you are moving to file.
Yes, I apologize. Thank you. Back on February the 6th, Mr. Riggins reached out to people and alerted them that our experts review needed the celebrate that basically the underlying data that is pulled, not the report that is generated from celebrate. What was the date that was put on the bill? February 6th. And then we received a response back, received another response files, or sometime later. And the next response I have is from May 28th. That there would be follow-up with the right person at TPD. And get back to us. So we've been in communication with the people about this for this entire time. There's no surprise we've been asking for it. And the response has generally been either that the DPD has it and they're working on transferring it, or that it's taking a really long time to do because the data is so great. They have to basically go through 3 different, take it from a hard drive onto another thing that can be transferred within hours, and then they can send it to us. And as of this morning, we are less than 2 months out now from trial, and given this huge amount of data, we have to have our expert look at it. We are very concerned that we don't have it yet.
Understood. So we do have trial set as the file. I've got set for October 6th. Just for months, five. So Mr. Makepeace, do you wish to respond to the respective bias stated so long as put on your notice 6 months ago?
Yes, John, and I'm not just getting the date of the emails that Ms. Quick referenced and the responses. There was a period of time where we had kind of, because it is an unusual request for the underlying file. They do, for the record, are in receipt of the cell phone forensic extraction reports that are generated, which are files that are usually turned over. Those are UFDR files. This is the underlying file that comes with that or is generated and then put into a report. They requested that on the dates and times. There was a period of time where I had to communicate with the OIC as well as the cell phone expert at DPD to figure out exactly what they were asking for. That did take some time, and then there was a period of time where I requested from the defense a hard drive that they provided to us for things to be uploaded onto. That hard drive, and I don't have the exact date in front of me, was turned over by Mr. Riggins to me. I transported that hard drive to the Detroit Police Department and provided that to the officer in charge of the case, as well as with the understanding that she and the cell phone expert would get together and get this uploaded. That's where I think the biggest delay comes from, is that there was a little bit of a miscommunication to them, between them, on our side of it, which is that one said it was done, one said that the other person did it. Nobody actually ended up doing it. When I went back to pick it up, it wasn't done. At that time, it was possible that was within the last month or so. The actual process for them to upload these or get files onto the hard drive is to take it from a Blu-ray disc or DVD onto the computer and then onto
I apologize, Mr. Riggins is out of the office for one of those next. Weeks. So we have 3.
First come back on. Something is certainly that you would be able to handle Mr. Higgins's absence. If not, by the way.
It is just, but I'm going to be in a 2-defendant homicide trial that starts on the 2nd. And it's in Judge U6, so I anticipate it going on Friday.
But we come back on Friday, September 12th. Good morning.
It would come after my exam. That was going to hurt me. 12 is not a good day.
12th is not a good day.
I can do the 11.
Certainly have to
I'm going to be in that 2-defendant homicide. It's in the 15th and the 16th. I know that's cutting close, starting to come close. But
on Tuesdays. Does that work for Jarvis?
yep, that works.
Okay. We'll come back Tuesday, September 16th, to listen to arguments on other acts noticed and people have filed. Let's set that hearing at 10 a.m. All right, were there any additional issues that needed to be talked about or addressed from people's perspective with today?
Judge, no additional issues. I would, in any case, I would just place on the record an invitation for defense counsel to come to our office to go through both paper and digital files to make sure that there are no other surprises. Just place that on the record. As quick, Mr. Riggins can communicate with me to set that up.
Absolutely. As noted, Chambers, we set our October trial dates far off in the future, of the hearing. Of course, the intent that all parties would make sure everything possible to make sure that this case is trial ready for October the 6th. So, on this one, we've got a trial date for October 6th.
I don't believe so.
Yes, Major.
But I tell you. All right, y'all. That was just a hearing, y'all. Excuse me. So I don't have time. And, and we're not going to get into our reaction. Woo, Lord, honey, put these glasses back on. Woo, I can't see, man. But look, y'all, that was just a hearing, and I got a lot of questions. Okay, I have questions. I got scared when I just finished walking, but I just ran here quickly so I can get this information to my subscribers. Okay, that subscribe to my channel. Because up to the most respect, most of them, majority of my subscribers work in school, mothers, fathers, busy. The hearing was normally disturbing, but I'm used to listening and listening. Whether you live in Detroit and you at the trial, it doesn't matter how you get. If you're at home and you watching the trial, you can watch it. Make sure my subscribers watching with me. So what I'm going to do is later I'm going to delete the commercials, but we are going to. Y'all know me. Y'all been knowing me for for a couple years. And we ain't worrying about the commercial because they're gonna come on, but we're gonna delete the commercial much as we can for the next hearing in September. Sometimes we're not going to complain. We're just going to work together, move smoothly, and stop worrying about so much. If you think somebody else, you want to watch it somewhere else, you can watch it somewhere else. That's one thing about me. It don't bother me. But I want my subscribers, my dearly subscribers, to please. We got to pay attention. I gather later on tonight because I promised my TikTokers I'm about to make some TikTok. But I promise later on tonight I'm gonna react to this. And this is similar to a lot of stuff that balancing that I was talking about. Now, this wasn't really too much about Messiah. It was really talking about the other little girl. I got questions. I got a lot of questions about the 4-year-old. If you were going to take a 4-year-old question and testimony, you need to do it then. Okay? Whatever a child say then. But mentally, some remember. I'm trying to remember when I was 4 at 66. 4 years old. I know some of the things that I did, but I don't remember everything. But so you can't say that a 4-year-old doesn't remember. A 4-year-old can't remember. I love y'all. I'll be back later to get my reaction on this. I'm not going to give it to you now. Love y'all. Peace. All right. I'm out, y'all.